Hello everyone. Good evening. Good evening, good morning, or good afternoon, wherever you are in the world. I want to say a special welcome to everyone that is particularly on this call right now. Welcome to the first class for the patent drafting course for our third and fourth quarter of our mentorship program. I would like to welcome all our mentees that are here with us and our mentors that will be joining us shortly. Thank you so much for taking out your time to being here. I know we'll be having a very exciting first class, and I'm sure our mentors will be doing due justice to the subject matter for today. So my name is Dennis Williams, and I'll be your moderator for today. I'll be handling the back end discussions around, or moderating rather, just moderating the sessions the session in general. So please, moving forward, we would like to just introduce our mentors for today so that we can quickly get into the business of the day. So our first mentor that we expect to join us shortly, I can see his AI is already on call, and I hope Mr. Rakesh is going to be with us shortly. Our first mentor for today, for today's class, is Mr. Rakesh Sharman. Mr. Rakesh is having a thorough and multifaceted career spanning nearly a decade in patent analytics, drafting and prosecution for EU and EP jurisdictions, US and EP jurisdictions. He worked very closely with various engineering teams and supported their portfolios for idea incubation to motivation management. Mr. Rakesh has excellent understanding of patent law, claims interpretation, and drafting skills. As a seasoned professional, he is readily engaged in various end-to-end IP services at different levels and provides intelligent IP solutions. He emphasizes more on promotion, innovation for a better world. He loves drafting patent claims, keeping all the infringement aspects in mind. Furthermore, he has a strong bent of mind towards IP automation and has sound knowledge of various IP tools, technique that can be used for either improving quality of IP or increasing their overall productivity. He is also an excellent mentor. He is also an excellent mentor and possesses all the leadership qualities required for a successful IP professional. Like I said, this is our first mentor for today, Mr. Rakesh. His AI is already on call, so I'm sure he'll be joining us shortly. And we look forward to hearing from Mr. Rakesh as we delve into the topic for today, patent search slash the legal requirements for patentability and patent strategy. Our second mentor, who is already here with us, is the lovely Miss Amosa Shukurat Modupeola. Shukurat is a seasoned intellectual property consultant, analyst, and educator. With public sector experience, she holds a master's degree in intellectual property from the prestigious African University Zimbabwe in collaboration with WIPO and the Japan government. Shukurat is an alumni of the World Intellectual Property Organization WIPO, a member of WIPO International Network for IP Education, as well as a training facilitator at NEXT Innovation Hub. She was a member of the planning committee for the WIPO National IPSC Competition 2023 and resource person at the National Intellectual Property Conference, NIPC. Shukurat is an accredited agent at the Intellectual Property Office in Nigeria and the pioneer of the Intangible Nuggets, an educational platform which is responsible for fostering, among other things, intellectual property advocacy, awareness, and education. Thank you so much, Ma, for joining us. It's always a pleasure having you here with us, running us through the different aspects of patent drafting, and like our topic for today says, patent search slash legal requirements for patentability and patent strategy. We will just be before we have Mr. Rakesh and then we have the mentees presentation, we want to just give you the floor for your opening statements and your presentation into the topic, and then we'll receive Mr. Rakesh. You're welcome, Ma. Thank you for joining us.
Hi, Dennis. Good evening, everyone. Thank you for having me. Thank you for the introduction. So I thought Mr. Rakesh was going to go first. Anyway, I'll go first. So the topic, patent search slash legal requirements for patentability and patent strategy. To start with, I won't want to dive into patent search. I'll start with introduction to patents so that we can understand what patent is and why patent search is necessary, or the importance of patent search. So I'm going to twist the topic starting with patent search on patents and patentability. If we are able to go into patent search today, then fine. If not, we can do that next week. So let me see. Let me try to share my screen so as to carry everyone along. Do you have my slide, Dennis? If not,
I don't have your slides, Ma, but
okay.
I can ask Sophie for it.
Okay, don't worry. Let me just check. Let me just check from my side here.
All right, thank you, Ma.
Share it. Give me some minutes. So while I'm doing that, let's just have introduction from the participants. And tell us your level of your knowledge level of patent, so I know how to go about the class.
All right, thank you very much, Ma. So while Miss Amusa is trying to find her slides and share her screen, please, we'll just be quickly taking introductions from our mentees. Starting, we'll just be calling at random. So you tell us your name and where your knowledge level of patents is, so that Miss Amusa can just help in the way she will be guiding us through today's topic. So please, starting with Abimo, please, if you can unmute yourself, and if you would turn on your video, I think that would also be better. So please tell us your name and where you are in your knowledge of patent drafting.
And where you are joining from as well, if you are not joining from Nigeria, like the country you are joining from. So we don't just look at Nigerian laws, okay? So we are able to look at the law as applicable in your country as well.
All right. Thank you very much, Ma. So
You're
please,
welcome.
Abimo, you can go ahead and start.
Good evening. Thank you so much. My name is Abimo Olaiwola. I'm joining from Ibadan, Oyo State, Nigeria. My knowledge of patents is still on the beginner's level, although I've been trying to do a lot of research on it lately and trying to come up with some patent claim drafting. But I would still describe my knowledge as the basic level. I have a baby crying here. Please pardon me.
It's all right.
All right. Thank you very much, Abimo. We'll be going next with to Abu Cynthia Chisum. Please, you can go next.
All right. Good evening, sir. Good evening, everybody.
Good
So
evening.
my name is Abo Cynthia Chisco. A final year law student in Enugu State University of Science and Technology. So my knowledge in patent drafting, just like the first speaker, I would say that my knowledge in patent drafting is at the beginner's level. So, and I look forward to gaining more knowledge about it. Thank you.
All right. Thank you
You're
very much,
welcome.
Cynthia. Next, I think we'll be going with Blessed. Blessed, please, you can introduce yourself. Thank you.
Good evening, everyone. My name is Blessed everybody, and the opportunity with some 5 years post school experience, and I can see, and also from being a city, those in Nigeria, and also I can see I picked
I
my
think your
ton
network
of
is breaking, Blessed. I really can't hear you.
Yes, we can't really hear you, Blessed. So please, can you come again?
everyone.
Blessed, your network is still shaky.
Good evening, everyone. Can you hear me now?
Yes, we
Yes,
can
it's
hear you
better.
better.
I'm Blessed Ogbedi by name. I'm a legal practitioner from Benin City, Edo State, Nigeria, and I can say my knowledge and understanding of patent is at biz level. So that's what there is to me, sir. Thank you.
All right, thank you very much, Blessed. We're going next with I can see Esther Chioma. Please, Esther Chioma, you can kindly unmute yourself and introduce yourself.
It's good evening, everyone.
Yes, good evening, Esther.
Good evening, ma. My name
Hi,
is Esther.
Good evening.
Yes, ma. My name is Esther Choma Onumono, and I would say, a recent graduate from Delta State University. I just signed out. And I would say I'm also a beginner to patent drafting, but I've done a little bit of research, but I'm still just learning.
Okay.
All right, thank you very much, Esther. Next is Joseph. Joseph, please, you can go ahead and introduce yourself.
Okay, good evening, everyone. Joseph Davo by name, legal practitioner here in Plateau State. I'm also a beginner in patent drafting. I would like to know more. Despite my research, I still find it difficult to understand it. Thank you very much.
Okay.
All right, thank you
You're
very
welcome.
much, Joseph. I think the last person we have here is Tonye Ikiba. Right, sorry if I didn't pronounce your surname properly.
Good evening, everyone. My name is Tony Kiba Tamno Toye. I am a legal practitioner in Abuja, Nigeria. So I would say I'm a little familiarized with patent, as I just recently filed 3 patent specifications for my office, but I'm opening to learning and gaining more insight on patent drafting.
Okay.
All right, thank you very much.
Do we have anybody else?
I think for now, that's all we have on the call. That's all the mentees we have on the call.
Okay, that's fine. So I'm going to share my slide now. Kindly confirm once you can see my slide.
All right, ma. We cannot yet see us.
Okay, how many minutes do I have, Dennis?
They're about 20 minutes, ma.
Were you able to confirm from Rakesh?
We reached out to him, but we've not been able to get a confirmation from him if he'll be present.
Okay, I haven't heard from him either. I'm not sure he might be attending, so let's see. Once I'm able to see my screen, just kindly confirm.
All right, your screen is being, yes, it's coming up.
Okay. So we are good, right?
It's not yet fully on screen. Okay, yes, it's up now.
It's on now, right?
Yes, it is.
Okay. All right. Hello, everyone. Good evening and welcome to the patent session, the Virtual Internship Mentorship Program, JIIPC. I am Amosa Shukuras. I'll be taking you through this program. So to start with, we're looking at definition of patent, patentable subject matter, what can be patented, what can be patented, patentability, patent search, and so on and so forth. Now, let's just juggle our brain a bit. So I'll be taking us through the introduction to IP, then we enter patent. So look at the inventor of a writing pen, the author of a book, and writer of a music. Somehow, they usually own their work, such that each time we buy these items, a part of what we pay goes to the owner of this work for their time, their money, their effort, their labor they put into the creation of this work. Now, this ownership attracts certain consequences when we, who are not the owners, when we copy, sell, or use their work without their consent or permission. The idea or the system behind this is where intellectual property comes in. So intellectual property gives you that ownership to something that you own, not something that you copy and paste or something that you borrowed for somebody, something that you own. And by ownership, it could be something that you own outrightly, and it could be a right that has been transferred to you. So the other owner transferred the right to you, and because of this, you are now the new owner. So it could be a statutory owner, or you could be the inventor, right? So what is the scope of intellectual property? Intellectual property, simply put, is the product of human mind that the law protects from unauthorized use by third parties. So from our introduction, it seems we have mostly law students or people with law background. Unfortunately, I don't have law background. That this is to say that IP is not limited to just lawyers. As long as you have that interest and you are ready to, go into the field, you can actually do IP. 7 years ago, I was a novice in IP as well, and I'm still learning anyway. So by doing so, by protecting the creation of your mind, what does this give you? It provides incentives. It promotes innovation, rewards your creativity and human endeavor. It serves as a catalyst for economic development and social and cultural well-being. It helps strike a balance between the interest of innovators and the public interest. It spurs economic growth and enhances the quality of life. Now, where does this striking a balance comes in? We look at inventors. You've invented something, and you tell the government, oh, government, see, I have invented this beautiful thing. It is new, it is inventive, and it's actually applicable. And I think it would be a good addition to our nation or our country. And because of this, I want to get this ownership for this invention. So the government is looking like, okay, fine, then let's do like a trade by barter, whereby you give me everything about this invention, and in return, I will give you 20 years protection period. But on one condition, you have to disclose everything about the invention. And the inventor looks like, okay, fine, that's a good deal. I love that. Then you write out your patent application, disclosing everything about your invention, starting from the title, the abstract, the field of technology, the background of the field, the drawings, the claims, everything is well disclosed, such that if somebody picks up that innovation or picks up that patent application after grant, they can do the same thing and arrive at your answer. Then that's a good one. And the government says, okay, fine, bring that to the patent office. We'll work on that, look at the formality, we'll do a formality examination because we don't do substantive examination in Nigeria. Then if your work is okay for a grant, we'll grant you a patent application, we'll grant you a patent, and we'll give you 20 years protection period, such that within that 20 years from your filing date, nobody has the right to use your invention until it expires. And when that 20 years expires, what happened? Your work goes to the public domain. And once in the public domain, everybody can still pick it up. look at it, produce it, manufacture it because what? It has expired. That way, we are able to have more things. So let's say somebody in maybe Ogun State is the owner of a patent on ballpoint pen, which one call Biro, and the patent has expired. Then somebody in Lagos State can decide to go through that patent and manufacture ballpoint pen because that patent has expired. So at the expiration of patents, now this is where the public interest comes in, because you can pick up that patent, work on it, rework on it. You can even upgrade it and file a new application for the upgrade you have added to the invention. So this is where public interest comes in. So most people, when they look at IP, they think IP is just to benefit the owners. No, it benefits both the owners and the public interest. And this is why we have exception and limitation when it comes to patents, copyrights, trademark, and so on and so forth. We have compulsory licensing. We have fair use. So these are things to benefit the public interest and not just the inventors alone. So IP is derived from two words, intellect and property. I think we all know this anyway. So the types of IP. So IP is broadly divided into two: industrial property, then we have copyright and related rights. So most of us said we've been doing some research, and you will see that whenever you do research, you realize that most of the treaties and conventions that speak to patent, trademark, trade secret, industrial design, GI, TK, plant variety, biogenetics, and so on and so forth, most of those treaties don't apply to copyright. And this is why copyright is a standalone right. It's not an industrial property. The main reason why copyright is not under FMITI, because what we have under FMITI is majorly the industrial property. And that's why we have patent, trademark, and industrial design. So when you're talking about IP, we shouldn't always classify copyright under industrial property, because when you talk about industrial property, you talk about Paris Convention, you talk about Strasbourg Agreements, you talk about NICE agreements, you talk about the new adopted treaty, you talk about Swakopmund Protocol, and so on and so forth. But when it comes to copyright, you talk about Berne Convention, you talk about the WIPO, the WIPO phonograph treaty, you talk about the what's it called now? The treaty for the blind, the Marrakesh Treaty, you talk about the one for related rights. I'm trying to remember the name of that one now. Skip my mind. So you see that most of these treaties are quite different, but those under industrial property, they have similar treaty. You see that TRIPS can never apply to copyright. Paris Convention will never apply to copyright. The same way Berne Convention will never apply to trademark and the like. So we have to understand the broad diversity in this. So how does this IP work? It's possible to have elements of IP. You can have all elements of IP in one single product. So these are an example of products we're working with. It's called the ballpoint pen. That's what it's called. Now, the patent protects how this pen works. The trademark protects the brand name, which is Big Biro, because two brothers come together to produce or to manufacture, to invent this invention, which is Big and Biro, and they decide to put their name together to make a name, Big Biro, which we know today, and we call all ballpoint pen Big Biro. Trade secrets is that proprietary information, that confidential information that they use in producing the invention. Then we have industrial design, the aesthetics, the shape. You see that when you look at different ballpoint pen, they have different shapes, right? When Big started initially, what they had was a case, an ink, and all. Then you see that as time goes on, they had one that you can press: red, blue, green, yellow, black, white. Now, how the pen work is not what the industrial design protects, but the aesthetics, how beautiful it is. That's what industrial design protects. Then copyright is the literary and artistic work. Let's say, for example, why they were coming up with probably the perfect shape for this ballpoint pen, probably they sketch something on paper. Copyright will protect those designs. So that's basically about having IP elements in a particular invention or a particular product. Now let's move down to patents, why we are here today. What is patent? From what I explained earlier, Patent is an exclusive right. In fact, all IPs are exclusive rights, okay? So patent is an exclusive right granted for an invention. Now, this invention, it could be a product, it could be a process or equipment that does what? That provides a new way of doing something, or what? Or offers a new technical solution to a problem. This is what patent does. And because of this, when you talk about patent, people feel like patent is all about machine and invention and anions and cations and engine. Something as simple as how you write with a pen can have a patent. Something as simple as going in a car, drinking water, and the water is not spilling because I have a straw. As long as it is new, inventive, and industrially applicable, you can have a patent for that. So when we are looking at patents, most people just come and say, oh, I want to file a patent. And you see that these three criteria of novelty, industrial applicability, and inventiveness, they are missing in what they are doing. The only thing you are likely to find is novelty and industrial applicability, but you will hardly see inventive step. And this is where we'll talk about the aspect of utility patent and business method in probably subsequent classes. So patent provides incentive to individuals. How does the patent do this? By recognizing their creativity and protecting their invention for a limited period of 20 years, such that no one can commercially make, use, distribute, sell, or import the invention without the patent owner's consent. Example, ballpoint pen, which is Big Biro, the brand name. So what is your right as a patent owner? A patent owner has the right to decide who may or may not use the patented invention for the period during which it is protected. Remember that it is just for 20 years. So if you don't take charge of that patent, if you don't work the invention, if you just decide to drop your granted patent at home and not do it for 20 years, then that's up to you. But if you maximize that 20 years, you'll be able to go into the market. We'll see that when Big started selling, for a very long time, we didn't see any other brand of ballpoint pen in the market. What we're seeing was just Big. But at some point, we started seeing Eleganza. I don't know if you were around during those periods, started seeing Eleganza. Then after a while, we noticed that we didn't see Eleganza again. Why? Because probably Big reached out to Eleganza saying, you don't have rights to produce or to manufacture this invention because we have a patent on it. And the reason is because whenever you want to file a patent, the moment you submit your patent application, there's a particular stage whereby publication takes place. They are going to publish that patent. So people can actually see the patent. They can see the application. And because of them seeing the application, they can then, am I still on or I'm lost?
Yes, we are still on. We can hear you clearly, ma.
So when they're able to get that, lay their hands on the application, because people feel like anything that is online is free, right? They decide to do the same thing. But once they still have that 20 years protection period, they have every right to stop people from using it. And because Big reached out to Eleganza saying, you can't use our patent because you can't use our patented invention because we have protection over it, then you see that after a while, we didn't see Eleganza in the market. But once it was 20 years, when Big patent expires, then we started seeing Lucky Cora, Cora Lucky, Lucky Cora, Cora Lucky, and different brands of ballpoint pen. And the reason is because Big's patent has expired. And just like I said, during the period of having that right over that patent, it was protecting Big's interest. But the moment the patent expires, it now becomes a public interest such that every other person can pick up that invention and manufacture Big ballpoint pen and make money from it without infringing. Because after 20 years, you have your rights or your invention goes to the public domain and anybody can pick it. So once you are still within that your right, you can sell the invention to someone else who then becomes the new owner of the patent. You can license it, you can do whatever you like for that 20 years. But what happens when it expires? Like I said, once it expires, your protection ends and the invention enters the public domain. This means the owner no longer holds exclusive rights to the patent, and thus it becomes available for commercial exploitation by others. If I'm too fast, please let me know. So let's look at patentable subject matter. Is it that if I have anything, any invention that is new, industrially applicable, and inventive, does it mean I can file for a patent? No. There's something called patentable subject matter. So firstly, your patent or your invention has to fall within the patentable subject matter. Because if you have a patent that doesn't fall within the patentable subject matter, even though it is new, inventive, and industrially applicable, you won't get a patent for it. You won't get a patent grant for it. So the first thing you want to look at first is make sure your invention falls within the patentable subject matter. And what are these patentable subject matter? Any new and useful product, process, method, machine, equipment, manufacture, or composition of matter. All of this falls within patentable subject matter. If you have an abstract idea, inventions that are contrary to morality, scientific theories or mathematical methods, discoveries of materials or substances that already exist in nature, method of treating human or animals, these are not patentable subject matters. They are not. And this is the reason why plants, that's the plant aspects of how do I call it now? The UPOV, the plant variety, it's not under patent, because if you look at what we have here, you realize that plants are not patentable. Plants are not patentable. So this is the reason why we don't classify plant variety as, we don't classify it under patent. So plant variety is under the Ministry of Agric and something, something, something. It's not under FMITI because it's not a type of patent. But if you look at our laws vis-a-vis the laws of other countries, especially UK, US, you realize that they have plant patents, they have design patent, and they have utility patent. Utility patent is what we call our own regular patent. Their own design patent is what we call industrial design. And their own plant patent is what we call plant variety, because their own patentable subject matter encompasses plants. You can protect plants. But our own patent law says that we can't patent plant because plants, the subject matter of plants is not a patentable subject matter. And this is the reason why we had to come up with a different law that has to cover for plant varieties, so that those that are into plants, like the biotechnologies, the seed technologies, they can come up with a protection method to protect their plants. So these are subject matter that we have to understand. So if your client brings a patent application that says method of extracting oxygen from the air, even though it is new, industrially applicable, and inventive, know that that patent cannot be filed because it doesn't fall under the patentable subject matter. So this is what I wanted to clarify here. Then we'll move to patentability of invention. Inventions in general must fall within the scope of patentability subject matter and fulfill the condition of novelty. I explained that earlier. So the first thing we are looking at is, does it fall under the patentable subject matter? If it does, okay, fine. Is it novel? Is it inventive? And is it industrially applicable? If it does, okay, then fine, you are good to go. But there will be issue with regards to inventiveness, because we realize that most of the patents filed in Nigeria are not so inventive. Our patents are majorly new, industrial applicable, but not very inventive. So let's look at this topic or these terms one after the other. What is novelty? This requires that the claimed invention must not have been made available to the public prior to the filing date of the invention. So we should have in mind that claim is like the art of our patent application. So anything that we are claiming that is new has to reflect in our claim. If you don't claim it, then you don't have protection over it. So claim is just like a brother to trademark class. So if you file a trademark application, let's assume you are doing business as a, should I say air vendor? And you know air vendors are protected under class 26 of the trademark class. So if as an air vendor, you left class 26 and you go and file your application under class 25 for clothing, then you should know that that's your trademark application is not going to protect your brand name for air. It's not going to protect you in the class for air. It's just like the same thing for patent. If you are claiming that, okay, my pen maybe is the style of writing, or there's something that makes it very sweet when writing, maybe that's the novelty part of your invention. If you don't claim it, it means somebody else can do the same thing because you didn't lay claim to that aspect of your invention. So when you are writing your claim, make sure you capture those essential elements, yes, essential elements of your invention. So the claimed invention, i.e., a claimed invention is not novel if all of its elements or features are found in a single prior art reference. So when you're looking at novelty, you want to look at what has been on ground before, and this is what is called prior act. You want to look at your own invention vis-a-vis the prior act, which has been on ground before, and say, okay, fine, this is what is existing before. This is the gap, or this is where the problem is, and this is what I am trying to do. So the patent examiner is able to read the problem in the previous invention and what you are trying to do to determine its novelty. And when we say novelty, novelty is not just new in Nigeria. Novelty in patent is absolute. It has to be new everywhere. Despite the fact that IP right is territorial in nature, your patent has to be new everywhere, not just in Nigeria. So you can't go ahead to, let's say, because the patent has been filed in the US, and because the IP law says that IP is territorial in nature, then you now go ahead to go and copy that invention that was filed in the US and bring it to Nigeria. By the time we do a patent search and we see that that invention is already existing, despite the fact that it doesn't have protection in Nigeria, you won't be able to patent such because disclosure, it has already been disclosed, and disclosure could be anywhere. It could be disclosure based on, it could be on social media. I think recently there was a patent, a design patent was rejected from Puma because Rihanna posted that design on our Instagram profile before Puma filed a design application. And you know, just like we have for patents, design as well, you should not disclose before filing. And they already passed their grace period, if at all they want to claim grace period. So disclosure is very important when it comes to patents. So, and this is the reason why we have to look at novelty. Like I said, novelty is absolute. Then we look at inventiveness. The invention must show an inventive step that cannot be deduced by a person with average skill or knowledge on the field. So there's something we call posita, P-O-S-I-T-A. It means person with average knowledge, or posita, person with average technical knowledge, something like that. That's what posita means. So whenever you see posita, just know it has something to do with inventiveness. That is, the person skilled in that art, or the person that have an average knowledge in that industry should not be able to deduce what you are doing. That's how you test inventiveness. Then industrially applicable, it means the invention must be of practical use. It's something that you can mass produce, because imagine government giving you 20 years for something that you just put in your room and only you benefit from. That means it's not for the benefit of every other person. So it has to be industrially applicable. So from here, we'll look at the patent application process. How do you file a patent? The first thing you have to do is your prior art search. And this is where patent search comes in. So imagine you want to file a patent application for a ballpoint pen and you didn't do any search. You just go and write. You submit your application in the patent office, you pay the fees, you do all of that, thinking, oh, I'm waiting, my application is going to be granted. Now, because we only do examination as to formality, your patent might, I didn't say your patent might pass. But when it comes to a point whereby someone comes about your patent and see that, this patent is similar to what has been on ground before, then they can raise an opposition. And by that time, that's when they will now take it up. And because of that opposition, the examination office might decide to look into the substantiveness of your patent. So I always advise people, it's better for you to file a quality application. So while filing, don't say, because Nigeria only do registration as to formality. Let me just file rubbish. Let me just file anyhow. At least it's only be protected in Nigeria. What if your patent or your invention is something that is very beneficial to other clients? Because if you file anyhow, I bet you that application is not going to pass in countries that do substantive examination. So while you're trying to file, or while you are assisting your clients to file as a lawyer or as a patent expert or as an IP attorney, try as much as possible to do a very good job, so that by the time the application passes, before that, you have to do your prior art search. You use different search engines like Patent Scope, Google Patent, XPassNet, and some other paid application software. We have JPO. JPO is also free. So do your patent search. Look at what has been existing before and compare it to what your client is doing to see if truly there is it's actually qualified for patent. So once you've done your patent search and you've gotten your results and you are able to file, what you do next is you have to draft. Now, when we talk about drafting, I think probably in the next 2 or 3 sessions, and Rakesh will take you through the drafting process. That's where you have the request form, you have your title of invention, you have your technical field, you have your abstract, you have your description. Under description, you have background, you have detailed description of the invention, you have the drawings, you have the claims, and so on and so forth. Then once you finish drafting and you file, filing is when you file to the ministry, FMITI, the patent registry, to get your patent patented. At that moment, there's supposed to be an examination process. Like I said, we only do as to formality. So what I'm going to check is, do you fill your form very well? Is your title patentable? The title of your invention, does it fall under the patentable subject matter? Is your abstract clear enough? The name of the inventors, is it on the application, and so on and so forth? Do you cite your claim properly? So just basically formality. If you pass that formality examination, then fine, you are likely to be granted a patent. But that doesn't mean your patent is quality or substantive enough to pass in another clime or in another country. So once the examination has been done, then the registry decides to either grant or refuse your patent, depending on whatever ground they want to reject or accept it for. And after that, you get a publication and certification of patent grant. So from examination to grant to publication is done by the patent registry. Then your prior art search, filing, and drafting is done by your IP attorney. So yes, patent search, that's the topic for today. Patent search, what is it? So filing a patent and acquiring a patent can be very expensive. Filing a patent in Nigeria is not expensive. You need to file in another country and see how expensive it is. So imagine after paying that amount of money, you realize that you are just reinventing the wheel and the invention has already existed. And because of this, there's a prior act that invalidates the patent application. And so you won't be granted a patent after wasting that money. So because of this, it is crucial, it is a crucial part of figuring out whether an existing body of work will interfere with your own ability to acquire a patent. So what is a patent search? A patent search, simply put, is a process of searching and identifying existing patents related to an inventive idea. Patent search can be done in various ways and using different available online tools. However, the best way to carry out this search is, number one, you have to brainstorm keywords. Say, for example, ballpoint pen. If you go on Patent Scope or you go on Google Patent or XPassNet or Lens Patent or JPO and type in ballpoint pen, I bet you might not get any results. Why? Because the name of the invention, the name of the brand of the invention is not determined while filing the patent application. So you can't use the name of the brand to search, because at the point of filing, they are only filing the invention. So what you want to look out for is maybe ink, case, pointed mouth, this and that. All those elements that makes up that invention is what you want to put in. So you have to brainstorm keywords. How do you want to put it? Do I put ink plus case? Or do I put pointed mouth and this? And use some boolean operators to look for to determine your keywords. So you have to be able to brainstorm brainstorm your keyword such that it helps you narrow down the search. Because if you don't brainstorm keywords, you can get so many results and you just get overwhelmed while trying to look at those results options. Then you want to look at the classes and the subclass. Just like we have nice agreements for trademark class, we have something called the Strasbourg Agreement for patents. And this we have class A to class, I think H or G, if I'm not mistaken. So each class has their own field. And this is where the field of invention comes in. So let's say your field of invention is medicine or agriculture. And assuming our patent system, a patent registry in Nigeria is very well organized, whenever a patent that has to do with the field of invention of medicine comes in, they take it to the department that handle medical patents. Whenever the one for agriculture comes in, take it to the department that handles agricultural patents. So this is why your classification is important. So you have to look at these classes and the subclass whenever you are searching to also narrow your patent application. Now, the searching patents and published application database. You want to use different databases because sometimes some databases have simple search, some have advanced search. You want to be able to know how to use different databases because the USPTO database might be different from patent scope, might be different from USPTO, might be different from JPO. So you want to know how each of these databases work and how they respond to your search input. Then the last thing is you may think your invention is original, but you can't be 100% sure without a patent search. And this is the reason why patent search is very important. Even though it may be expensive, it helps you to understand what and what. It gives you a view of, should I go ahead? Should I stop? Oh, okay, I've seen this. What else can I do to make my invention more acceptable so that I'll get a patent grant instead of just going ahead to file without doing any search? And on that note, we'll look at the types of patent search. So you want to determine, what am I doing a search for? What search exactly am I doing? Am I doing a prior art search? Am I doing a validity search? Am I doing a freedom to operate search? Am I doing evidence of use search? Am I doing state of the art search? So there are different types of search. Depending on what you are searching, you'll be able to focus and say, okay, fine, this is what I'm doing. So let's assume you want to invalidate somebody's patent, probably because it is not new, is not inventive or industrially applicable. What you are going to do is not a prior art search. What you are going to do is a validity search or invalidity search so that you can invalidate that patent based on the fact that you have an application or you have a document that is similar to what the person has, such that the prior art invalidates the person's patent. So in that kind of case, you are doing an invalidity search, not a prior art search. Also, if you want to, let's say, there's a patent in the US and you sell, you produce that particular thing in Nigeria. You want to see, can I also sell, or you want to see where can I sell these products? Because you can't sell a patented material in the country where that application was filed. So if we have an application for ballpoint pen filed in US and they have a granted patent in US, and let's say Eleganza determined to manufacture Eleganza biro in Eleganza in Nigeria, they now want to take Eleganza and go and also sell it in the US. Now, because Eleganza's invention, or the way Eleganza got their own invention process from Big's patent, they won't be able to sell in the US because there is a patent on that invention in the US. So that is called freedom to operate search. You want to carry out a search to see, oh, do I have the freedom to produce or manufacture this my product in so country? So you want to do all of that. So you have to understand the type of search to help you whenever you are doing your search as well. How many minutes do I have left, Dennis? So I can just round up.
Sorry, Ma, you said?
I said, how many minutes do I have left so I can round up?
Okay, you have there about 5 minutes, ma'am.
Okay, so this is an example of your prior art search. This is Google Patents. So when you go to Google, you type in Google Patents, it takes you to a platform of Google Patents, and you can either enter your publication number, your patent grant, the title of the invention, and so on and so forth. Here you can look for granted patents. You can look for published materials, because once you are doing your prior art search, you are not just limited to search patent document as well. Like I said, any disclosure can invalidate your patent. So something as simple as publishing your work on a journal can also invalidate your patent. So you want to search maybe patent search, you want to search non-literature material, and so on and so forth. So this is how the Google patent database interface looks like. So I think, yes, what I have here is drafting and filing. So that's all with respect to search. And I think we can take the next session and answer questions. Thank you, Dennis.
Right, thank you so much, Ms. Shukurat, for that wonderful presentation. I think there are about 20 to 30 minutes, she has helped run through basically everything that pertains to patentability and also patent search. And I hope our mentees were paying attention while she was giving her lectures, and like giving her lecture, and it was not just about you being in class, but you were actually taking notes and you were paying attention. So moving forward, because of the nature of our program, we just don't give room for mentors to come just share their knowledge. We also give room for our mentees to also present to us a basis for which they've done their research. They've also learned what they've learned over the course of the week, where we're giving them the topic and work to research on. And we expect that they also share with us their knowledge based off of that research. And we have our mentors also give room. We give our mentors room to give feedback to the research, what they can identify as some of the gaps in knowledge, and they can also help better improve the learning process. So please, we'll be having presentations from the mentees right about now. Mr. Rakesh, I think he's unavailable and won't be able to join us for today's session, but hopefully he'll be joining us in the subsequent classes. So please, the group presenter for this particular class, please, you can share your slide and start your presentation. You have 7 minutes for your presentation. Do we have the group presenter here with us? If we don't have the group presenter here, please can we have the backup presenter? Okay, I can see Chisom. Chisom, are you with us? Okay, I think Chisom is supposed to be our presenter for today, but if she's not, if she's having network issue, can we have the backup presenter step in to make presentation on behalf of the group? Hey, Chisom, are you with us, Chisom?
Yes, sir. I'm on the call, but my network. I've been having issues with my network. So
Okay, sorry about that.
please, sir, I don't know if you have the documents, so you can explain.
All right.
If you have the documents with you, so you can help me share.
All right, I will do that, but please, you can start up the presentation while I try to put it up.
Yes, sir. Good evening once again, everybody. I am Abositi Chisom, so I am the presenter for today. So what we will be looking at is patent drafting. So I'll give a summary of what I would say in the course of my presentation today. So first off, I'll be giving a general introduction of what patent is and a definition. Then secondly, I would say what a beginner is supposed to know about patents. And furthermore, I'm going to talk about the criteria of which any person applying for patents is supposed to follow or would check before applying for patents. Then I would mention examples of patents and then the importance of patents. So as we have on this our first slide, I would like to explain it with an example that can be deduced from what our lecturer for today used. Basically, patent is just a kind of right, an exclusive right given to an inventor that excludes every other person from that particular invention. That is the right is given to the person over such product or invention. So in defining patents, I would
Cynthia, are you with us? Cynthia, can you hear us?
Please, Williams, can you please confirm if you can still hear me? I was logged out.
Hello,
Yes,
William.
we can hear you now. I said we can hear you now. Please go ahead, carry on with your presentation.
I can't hear anything on the.
I said I can hear you now. Please carry on with your presentation. Cynthia, are you still with us? Sorry about that. I was trying to shuffle using my two devices. So please, Cynthia, are you with us? Okay, please, can we have someone? It seems Cynthia's network is quite poor. So please, can we have someone from the group just step in? I will reshare the slides, so please, we can continue with the presentation.
Good evening, everyone.
Yes, good evening, Blessed.
I'm just Kweli by name myself. I'm about to for like giving a brief introduction into our practice.
I can barely hear you, Dennis.
Sorry for
Can
this.
you hear me? Blessed, your network is very poor. Please, can you speak up?
Can you hear me now?
Yes, we can hear you better now.
All right. Now, the commandments those of us that are associated shall not
Are you
steal.
using AirPod? We can't hear you. It's very faint.
Not at all.
It's very faint. Probably you want to go to a place where the less.
Can you hear me now?
Yeah, it's a bit better now.
All right. Good evening, everyone. I was saying I will want to show you the topic of the presentation. The 10th commandment says, "Thou shalt not steal."
Sorry, again, it has gone bad again. It has gone bad. Your voice has gone very low.
Can you hear me now?
Please, can you turn up your speaker so that maybe with that we'll be able to hear you better.
Hear me now? Can you hear me?
It's still a bit poor. All right, Blessed, it seems you have issues with your audio. If we have Chisom back on call, or Cynthia rather back on the call, please, you can carry on with the presentation. Cynthia, can you hear me? Okay, it seems our mentees are having, our presenters are having. Okay, yes, please go on. Please go on. Cynthia, if you have to, please go on, carry on. Okay, I think we have a peculiar issue in this particular class. Both the presenter and the backup presenter seem to be having very serious network issues. So please, can we have someone else from the group, because the expectation is that you people collectively put in the effort to make the presentation. And if we are having this particular issue, anybody from the group should be able to step in to make presentation on behalf of the group. So please, can we have someone else from the group with better network connection to help run through the presentation?
Good evening.
Yes, good evening, Esther.
Okay, let's do that. I think I have better network connection.
Yes, all right, thank you. Please carry on.
Right. All right, the first speaker already gave a sort of what the presentation is about. So I'll just through the slides quickly. Now, she was about introducing, she was talking about defining what patent protected. And from our research, we found that patent itself is a legal right granted by the government to an inventor to exclude that importing or making that's mass producing the invention for a period of time, and it's usually 20 years.
Esther, can you hear me?
Yes, I can hear you. Can you hear me?
Yes, your voice is, or your audio is it's going up and on, like it's not stable.
Okay, can you hear me clearly now?
Still a bit slow.
Is it clear now?
Yes, it's better now.
Okay. So I was saying that the first presenter had given us of what our presentation is about, and then she was about to give introduction when her network cut her off. So from our research, we understood that patent is actually a legal right granted by the government to an inventor to exclude others from introducing or using his invented work without his permission. Now, we found out also that patent does both protection and it does both protection and exclusion purposes. It excludes others from using the inventor's work, while it protects the inventor from enjoying his work. Please, next slide. Yes, what a beginner should know about patent. So a patent is granted to a new and non-obvious invention. Like our taught us, our mentor that taught us during the presentation class, we must first conduct prior art search before we apply for or even draft a patent to ensure that the work itself is patentable and that nobody else has applied for patent for that particular work. Please, next slide. So the criteria for patent are generally, these are general criteria because I didn't even know the nuance until this evening. The patent must cross three hurdles before it be granted. First of all, it must be new. That's the novelty criteria. So there must be an inventive step. So the person must really do something. If it's an improvement on a product, it must really show that the improvement itself, there was actual work done on the invention. And then the third one is industrial applicability. It must be useful to a particular industry. You cannot just invent something that's not useful to anybody. Next slide, please. Now, examples of patent drafting. The first one is utility patent. We have design patent. We have plant patent. We learned from this class too that Nigeria does not cover patent. So it does not cover plants rather in its patent. Utility patent protects useful processes. It covers patent for inventions that serve particular processes. They make
Louis, your audio seems to have gone bad again.
Can you hear me?
Yes, we can hear you now.
Okay, design patent. Now, what design patent protects is virtually the aesthetics, like what the product looks like, the difference in the product. For example, the patent granted to Coca-Cola for the shape of their bottle. That's a design patent. Then we have plant patent for a different kind of variety of plants. It's not mentioned here, but while we were compiling, we realized that there are different kind of there are also some things that a plant patent must cross before it be granted. And one of them is it must be sexually produced. Please next. Okay, importance of patents. The first and most important, in my opinion, the first importance of patents is it safeguards the invention of the inventor. It protects the invention of the inventor. Secondly, it grants legal rights to prevent others from another's idea without his or her permission. Then it also ensures that the patent meets the required standard for its effectiveness. So you don't just produce, but meet certain standards, something that can be useful, that will not be harmful to the public. It also creates a process of detailing the uniqueness of invention. Like our mentor taught us, after the period of the patent elapses, they should be able to use the method to mass produce. And the last, detailing the invention strengthens its validity, the patent validity. I think that's the last slide. Thank you very much.
Thank you very much, Esther, for helping us complete the presentation. I think today the network decided to be our enemy, but irrespective, I want to say well done to the group for putting together that presentation. Thank you to Cynthia and Blessed who were willing to carry on the presentation, but unfortunately because of their network, they couldn't. And thank you to Esther for stepping in. The essence of the group work is that collectively the group puts in the effort to carry out the work. And once that is done, irrespective of whether the presenter is available or not, someone from the group can always step in to make the presentation on behalf of the group. And I want to commend everyone who is a part or who has been a part of that work. Well done to you all. So now we'll be giving the floor back to Ms. Shukurat. I know she had a part of the presentation, right? So please, Ma, I would like for you to speak to their presentation and give them some feedback.
All right. Can you confirm you can hear me, Dennis?
Yes, I can hear you, Ma.
Okay. So I think I saw the presentation, and in as much as we have network issues, this is why it's always important for everybody to always participate in working on slides, because if Esther wasn't able to participate during the making of the presentation, she might not be able to present today. And issues like, or should I say, situations like this discourages mentoring, because we have so many things to do. But we take out our time to come here and mentor you, and at the end of the day, we have just one single person to present on behalf of the group because of networking. So in subsequent sessions, it's always advisable for everybody to participate, so that you're able to present. And while doing this, you also benefit yourself because you understand more. You are able to understand the aspect of patent and ask questions in that regard. So back to the presentation itself, I understand that most people are beginners, so I don't expect a perfect presentation, but it's a good job. However, I encourage the group to do more detailed research, because your should I say, your slide didn't really say much about what exactly it is you are doing. It's just very kind of basic. It's not too detailed. So in your next presentation, probably next week, you want to carry out more research. You have just 7 slides, and the slides just talked about introduction, what a beginner should know, the criteria, examples. Now, when it comes to criteria, there's no expansion or more detailed explanation about novelty, about inventiveness, about industrial applicability. There was no mention of the patentable subject matter. So you want to do your research so that you are also informed. And when you are presenting so that you know what you are saying. That way you have more knowledge about patent as well. Then there's no mention of, like I say, the laws or the treaty guiding patent, because before you want to talk about intellectual property, you must understand the convention and treaties. And that's why when I started with the basics of intellectual property, and I talked about the industrial property and copyright. And I talked about the fact that the treaties guiding the industrial property, such as TRIPS, Paris, and so on and so forth, they are not applicable to copyright, because copyright is like a standalone on its own, and the treaties applicable to copyright are also not applicable to industrial property. So there's no how you talk about patents and you won't talk about the Paris Convention, because even from your definition, it's expected that you lift some of the given out by these conventions, or maybe these treaties, or maybe even micro definition, Professor Fisher's definition, Professor Yusuf Okede's definition, Paris Convention definition, TRIPS definition. That way it is obvious that you did your research. But just going through Google, and sometimes these days, everybody is just turning out information. You don't even know which one is correct. So getting it from the source by the conventions, the treaties, the international bodies, and the national bodies. Even if you check the Nigerian Patent Act, you will see definition of patent. So you want to make sure you are getting the right definition, to back up your slides. And to also be good for you if you are able to put in maybe the criteria as regards the law, let's say the Nigerian Patent Act. What does it say about the criteria for patentability? You might want to put in some of the acts just to make sure that, oh, these people did their research and they're actually saying what exactly it is they know. But like I said, it's understandable that you're beginners, but going forward, you want to, look at it. I think from even the one we have criteria for patent application and example of patent drafting, I think those slides are empty. So you just want to put in one and work as a team. So I would say when you want to start the work, you can divide the topics and give topics to each person. So each person has a particular topic they're supposed to work on and submit before you now collate it into the final presentation. So I think you've done a good job, but you can do better going forward. So at this junction, I'll probably take questions.
All right, ma'am. Thank you so much, Ma, for that feedback and that input. I hope the mentees were listening and they are going to eventually put into consideration all that you have said about researching and giving a better presentation. So please, we're going straight into the question and answer segment. After that, please kindly note that we'll be taking a quick screenshot of today's just for better capture of the class and for attendance sake, right? So please, we'll be taking screenshots after the question and answer section. So kindly note that if you are in a position where you can turn on your video, please, you can start positioning yourself to do that for the screenshot. So please, we'll be going to the question and answer segment straight up. Okay, Blessed, your hands are raised. Please, you can unmute yourself and ask your question. Okay.
Good
evening.
All right. I just have 4 questions. I said them on
I
the
can
chat.
barely hear. So Dennis, you just cannot help me interpret once it's done, okay?
All right, ma. Oh, Blessed,
Or
please,
you
you can
just
send your
type
question.
it.
Yes, into the chat box. Okay, I can see you already put one here. The question is about freedom to operate search. Does it only refer to patents that have been registered? And how much is required for filing patents? And then there are a few other questions here, ma. Can you see them?
Okay, it said about freedom to operate search. Does it only refers to patents that have been granted? Yes, only patents that have been granted, because you only need that freedom. You only need permission to use the patent because it has been granted. So there's no point getting permission for a patent that has not been granted or for an invention that doesn't have patent protection. So it's basically for patent that has been granted. So that is, you are trying to make search based on the fact that a patent has been granted and maybe you want to manufacture that patent in so country. So you want to be sure that, am I sure I'm safe to manufacture this product in this country, or is there a patent grant on this invention in this country? So you are not infringing. So the search is just for you to avoid infringement liability. That's what the patent freedom to operate search is about. How much is required for filing patents? Well, it's not a one-way thing, because officially there's an official fee, but there's a fee your agent is likely to charge based on the work they're going to do, put you through consultation, drafting, and all. So it's not a one-way fee, but I think it's within, let's say, I don't know. I don't want to give you the wrong fee because everybody charge based on your experience, the amount of work you are doing, and how intensive the work is. So let's assume you are filing the whole application. That's very intensive. So you might want to charge more. But if you are working on the claims alone, so that the client will be the one to draft every other application and you're drafting only the claim, then you might want to reduce your fee a bit. What is the range of professional fee to charge? Professional fee, like it also depends. It depends. 200. It depends, sincerely. It depends, because some people charge more than 200 for trademark. So imagine charging the same 200 for patents. Just charge based on your capacity, your brand, and how people know you. So imagine you are just starting and you want to say, let's say you are charging 400 for patents when you know you don't even have the client base yet, and you don't even have that level of understanding. Maybe you are even going to give the work to somebody else. So you want to charge reasonably. And while your brand is increasing, while your knowledge is increasing in the field, you might decide to start increasing your fee bit by bit. Database, does country each have their own database, or is it the hands of private organization? So when it comes to, as an IP office, every IP office should have their own database, ranging from trademark, copyright, industrial design, patents, TK, GI, and so on and so forth. Because as long as you are receiving registration, you should have database whereby you can check, is this application existing or not? However, it's quite unfortunate that we have a database in Nigeria, even though it might not be so extensive, but this database is not available for people or individuals to check. So if you want to do any search, be it patent search, trademark search, copyright search, blah, 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 you have to go to the concerned registry. So if you want to do a patent search, you go to the patent registry in FMITI and you tell them you want to carry out a search, you pay the fees, they do the search for you, give you results, then you can probably draft a report for your client. The same with trademark. You can't file trademark search yourself, even as an agent. So even as an agent, you can't file yourself. You have to get someone in the registry to do it for you manually. But if you are an agent already, you see that there is a space for patent search or trademark search on the online platform. It doesn't work. So don't go and think you search yourself and get results. You need someone in-house to search for you. Is the search at the physical registry or online? It's the search. Now, as a patent agent, you have a database whereby you can file your application, but you can't search online. All search are done manually. So all you need to do is get someone in the office, send them your search terms to help you search, and they'll send the result to you. So that's it about search. I think that's all. So, okay. The IP offices, are they run by government or private? All IP offices are run by government organizations. They are running by government organizations. So we have the NCC, the Nigerian Copyright Commission, it's run by the Copyright Office. We have under FMITI. FMITI is actually broad. FMITI is the Federal Ministry of Industry, Trade, and Investment. So because it has something to do with trade, investment, and industry, that's why we have the patent registry, the trademark registry, the industrial design registry as well. So we have the patent and design registry. They are together, though there are other aspects, there are other organizations or agencies there. But when it comes to the commercial department of FMITI, is where you have the patent registry, the design registry, and the trademark registry. Okay, so they are all run by government. Using the ballpoint example, would it have been possible for another company to have produced and sold in Nigeria if a patent of BIC was granted in America? So if BIC's patent was granted in America, then somebody in Nigeria wants to produce the same thing. You can, as long as you are not filing a patent application for it, right? You are not claiming ownership. What you are doing is just, so like I said, your patent application is limited in the country where you filed. But if BIC and Bio, as the owner of the patent, if they file the application also in Nigeria, after they filed in America, then somebody in Nigeria cannot do the same. You can't manufacture it. You can't do anything. But if they did not file in Nigeria, then you in Nigeria, you can manufacture that invention, but you can't file a patent application because of the issue of novelty. It has already been disclosed. And like I said, disclosure in patent is absolute. So because it has already been disclosed, you won't get a patent on that, except maybe you are bringing in something new to upgrade or to build on the invention. So I hope that answered your question.
Thank you very much, Ma, for helping us with the answers to those questions. I think I myself also have a question, just to round up the session. For instance, let's say we have a clipper, the inventor of the clipper, right? He invented the clipper, but he didn't invent the guard for the clipper. Those things they put on clippers to just help the smoothing of the barbing, right? Can the person who invented that guard, can he also file for patent, since it's like a sub, it's used in proportion to the clipper too? Can he also file for patent?
Okay, so what happens now is, I don't know if you've ever researched on patent, really. There's a part that always says patent is a negative right. I don't know if you've come across that. If you check, says they always say patent is a negative right. And the reason why patent is a negative right is that because most times the inventions are not disruptive. They are just additional inventions. They are based on something that's already been existing. Do you get? So you are not coming to the market newly. So what exactly you are doing, because your sub part to the clipper will not work without the clipper, right? So because of patent is a negative right, what this means is that you, as the patent owner, you really do not have the right to work your invention, because in most cases, your invention is dependent on somebody else's invention. So because of this, if you want to work your invention, you need to get permission from the owner of the patent for clipper first, because your claim will have one or two things to do with that clipper before you can now attach those sub parts to the clipper. Except if the patent application on clipper is expired, then you are good to go. But if that invention or if that application is still in force, that is, if that clipper invention is still in force, you can go ahead to now manufacture the clipper and now put your own parts. So in most cases, you need license from the owner of the clipper patent before you can now put that in your claim. Or you have to make sure that you are not claiming clipper. You are only claiming the sub applications to add to the clipper. So you have to be very vigilant.
Right. Thank you very much, Mike, for that. So we've come to the end of today's session. Like I earlier stated, we would like to take quick screenshots for those who have some form of lighting.
Okay, so just a quick one, Dennis. So for those who are still interested in patents and you would like to build your knowledge in patents, there are numerous courses you can take to build your knowledge. In fact, when you are doing your research, try to use documents or research materials that are written by people in the field. Because like I said, people just go to Google, read, and just put out something. They don't even know the applicability, because applicability is different from what you just read online. If you see most of these things you read online, when you come to apply it in terms of applicability, it's quite different, right? So you want to make sure that you are learning from the right sources. And you can go to the JIIPCC website, www.jiipo.int. I just posted it now. So www.jiipo.int. When you go there, you can register to take JIIPCC courses. So for those looking at taking patent courses, you can start with the beginner course, which is the DL 101. I'm going to communicate with Dennis. We are actually running a program presently. Unfortunately, the slot is filled. We aren't taking any other slot. So once the slot is open again, I'll reach out to Dennis to see those who are interested in taking the JIIPCC courses. We're going to start with the beginner courses, and that way we keep advancing. And those that are really doing well might get scholarship to take the advanced courses. So I think that will be it.
Right. Thank you very much. Thank you so much for that information. Please, hope mentees, hope you heard that. This is Ms. Shukurat just opening the door for us to advance our knowledge and our insights into patents. So please, if she passed that information to me, I will do well to also communicate it to the So please, can we turn on our video camera so that we can take a quick screenshot for those that have lighting in their background? Okay, thank you, Esther. Please, can we have a few more people? Thank you, Blessed. Can we have some more people turn on their video camera? All right, thank you, Ma. It's nice seeing your face.
You're welcome. I don't think it's so bright here anyway, but let me see.
That's not an issue.
All right, please give me a moment.
We said cheese. You're not giving us this now.
I think that's fine, Ma. Thank you very much. All right, thank you.
Okay. So in our next class, I want to see a better presentation. I just dropped my social media handle. You can follow me on Instagram, The Intangible Nugget. You can also follow me on LinkedIn. I'm also Shukrat. So I post opportunities and all that are available, and you can also learn from my posts.
All right, thank you very much, Ma. It's been a wonderful 1 hour, 30 minutes there about with you and with our mentees. We look forward to seeing all of you in the next class. Please, for those who are not in the session, please, you can also send them messages so that we have a better, a more fuller class in the next session. So thank you, everyone. Good night and enjoy the rest of your evening.
Bye.
Bye-bye.